thank you everybody for attending. My name is Leah Grinvald, and I'm an associate professor at Suffolk Law in Boston. And today I want to talk about my recent project, Contracting Trademark Fame with a question mark. And just to give you an overview of the questions I'm thinking about with respect to this project, my overarching question is really a theoretical one, looking at, should we be importing one theory that kind of works in one area of the law into another area of the law without further scrutiny? And more specifically, should contract law's objective theory of contracting be imported into trademark law to actually prove strength or fame? And so a footnote on strength or fame, I'm going to probably be using the term fame throughout the presentation, but really I'm incorporating sort of that spectrum of trademark fame, from secondary meaning distinctiveness all the way up to famousness for dilution. And so I'll give us a brief primer on first year contract laws if we don't remember. For those of you who do remember, we have something in contract law called this objective theory of contracting, whereby we assume, for various reasons that I'll get into later, that as long as the parties have reasonable notice of terms, and this is applied with respect to offline as well as online agreements, as long as they have reasonable notice of the terms, regardless of whether they've actually read those terms, they will be considered to be bound by those agreements so long as they have expressed some outward objective measure of assent, right, consent. So that's why it's the objective theory of contracting. Empirical work actually shows that, not my empirical work, others' empirical works, has shown that less than 1% of all of us are actually reading these terms. But they're considered binding, and we've got lots of good contract law precedent on the books that tell us it's binding, even though, we don't know anything about them, right? And so savvy lawyers with respect to online agreements are sort of rationally taking advantage of this and inserting all sorts of really interesting provisions into these agreements, including ones related to intellectual property law. And so, and they're extremely protective. Where online agreements and trademarks coincide, are on the online websites, are in three different categories. So we've got, an example of specific call-outs of trademarks. So we have here Instagram. The Instagram name and logo are trademarks of Instagram, and they can't be copied, imitated, or used. We've got LinkedIn, which calls attention to the LinkedIn stylized and then the in logo. We've got Amazon, which down here, under their conditions of use, it's kind of small, it tells you you can't do a number of things with their trademarks, including you can't disparage them. And they include, this is sort of a type of specific call-outs of trademarks, they include a link to their non-exhaustive list of trademarks, which includes a listing of 462 trademarks, which most of them I can guarantee we've never heard of before, and include very generic ones, maybe even A to Z, right, and others that are quite problematic with respect to distinctiveness, validity, and whatnot. Another second category is where you have this catch-all, kind of like Tumblr, but it's adjoined by a branding guideline. So we've got the catch-all, sort of, you can't use any of our trademarks, but you can use them in accordance to our branding guidelines, and then they specifically call out, trademarks on the branding guidelines page. And then lastly, you have just the, regular catch-all, everything on our website, including buttons, headers, colors, is a trademark or a trade dress, and we're claiming protection. And so, again, I mentioned that these provisions are rational, right? From a company legal standpoint, you want to protect your IP. Trademarks are our most valuable, one of our most valuable intellectual property rights these days. And so I'm not arguing that these provisions are per se necessarily a bad thing. They may have some value in terms of notice, providing provisions to the world, that just like marking does, right? Marking something that's a TM, you're providing, putting folks on notice that you're claiming it as a trademark. And so there may be some notice benefits to that. Where I have a problem with that is that there have been some, I will argue, some more nefarious uses of these provisions that kind of coincides with the objective theory of trademark law, objective theory of contract law, and this has to do with how hard it is to prove fame. And as we all know, it's very hard, right? That from secondary meaning, strength to fame, we've got various steps along the way, and courts have a fairly high hurdle. At least they ostensibly argue or recite that they have a high hurdle to cross over in order to prove, at various stages of a trademark's lifespan. And what companies have been trying to do in inserting these clauses is, and I've seen this in opposition proceedings, most notably at the PTO, is arguing that we have X number of users, and then therefore this mark, which is not necessarily a dominant mark, right? Doesn't necessarily appear on its own on the website. It's perhaps a portion of a mark. And so I'll give an example of Facebook, right? So Facebook has argued several times in opposition proceedings that F-book, right? Have we ever seen F-book used? I haven't. And then separately, book are famous because of their numbers of users. And so implicit in that argument is this objective theory of contracting, meaning, well, our users have agreed to acknowledge our marks, right? Because these clauses are, putting them on notice. And what do you do when you put something on notice? You sort of, and it's contracting, and you're going to be bound by that, so you've agreed to acknowledge our trademarks. And so that's why, and then that's part of the story. The other part is that it seems like the courts and the PTO are sort of buying some of these arguments, and that's, I guess, the most concerning. We've got a number of different cases that show us that courts are actually quite willing to use license agreements, contracts, and user license agreements as good evidence for in other areas of trademark law. And so one example is a very recent case out of the Middle District of Florida that Eric Goldman actually just blogged on. It's called the Meth Lab Cleanup case. And there we have, it's an offline agreement, it's a settlement agreement, where we have ostensibly the trademark holder obtaining from the settlee an agreement that they're going to consider meth lab cleanup, which is arguably a descriptive term because that's actually what they do. I'm sorry.
Generic, possibly.
Maybe generic, exactly, right. But the settlee has agreed that they're going to consider the mark as distinctive, and they're not going to fight the validity of the mark. And then, we've got later, litigation with respect to that and use because the settlee has used the mark as a meta tag on their website. And so the court finds in favor of the trademark holder because of this agreement. And so it's not quite, on square with what I'm arguing about, but I argue, and we've got a couple of other cases, that talk more about, contracts and the use of contracts to prove distinctiveness as well as strength, simply because we have this agreement between the parties. And so, I argue that we have this potential that courts could and the TTAB could adopt this, and I would say unknowingly, obviously, and unconsciously, because we don't really ever get this explicit, I believe that this theory is a good one, but I argue that this is a concern. And so, you might say, well, why would this be a problem? And I posit two reasons. The first reason is this theoretical disconnect between contract law on the one hand and trademark law with respect to distinctiveness, strength, or fame on the other. On the one side, contract law, and particularly with respect to this objective theory of contracting, is really premised on business efficacy, right? Efficiency. We want contracts to be valid for the most part. We want to we imbue all parties with free will to enter into contracts, and unless the parties can prove otherwise, courts are quite happy and judges are quite happy to enforce contracts, particularly where we have these outward manifestations of assent. And it's quite messy and inefficient to sort of start digging into subjective intent, and we sort of long ago tried to, jettison that, the whole subjectivity with respect to contract law. And there are problems, and there is pushback within the contracts community, the contracts academic community, about that with respect to online agreements. Nancy Kim, who straddles both IP and contract law from Cal Western, has written, extensively on that. And I fully agree, but, in terms of, why this isn't going to be good in terms of trademark law, well, trademark law, on the other hand, is sort of, I would say, completely opposite, right? We are not looking, we're not looking at fiction, right? So on the contract side, it's really a fiction of whether or not the parties have assented or agreed to the same terms. Trademark law, we're actually trying to look for reality, right? As much as we use, proxies for that reality, the end goal is to put yourself, right, the judge, the trademark attorney, TTAB, judges, to put themselves in the shoes of the consumers and try to say, well, what do the consumers actually think about this? Do they actually, is it really distinctive? Is it really famous? As a trademark. And so there's this theoretical disconnect between the two. And the second reason why I think this is a bad sort of movement, and it's a problematic movement, is that we are lowering, in essence, the burden of proof for some trademark holders, right? That we have very large trademark holders out there, like the ones I've surveyed. I've actually surveyed like the top 50 websites as determined by Alexa, also owned by Amazon, for those of you who don't know. So perhaps, maybe I need to find something more objective. But I've surveyed the top 50 websites, and all but 6 of them have very similar clauses that fall within one of these 3 categories. And Amazon is probably, I would say, the outstanding one with 462 trademarks listed. But for example, Apple lists 260. Microsoft lists 190. They also claim trademark protection in their font names and things like, other problematic things like that. And so what we're doing, if we allow for this trend to continue without sort of stopping and thinking about it more carefully, is we would be in essence lowering the burden of proof for fame or anywhere along the spectrum of the distinctiveness inquiry, and allowing some trademark holders to acquire large swaths of our English language. It kind of fits quite neatly in with Barton and Jeannie's project of sort of, the end of sort of corralling the words on the registry. And that's really problematic, right? Particularly where we have a new trend that I've been seeing in where large trademark holders are attempting to assert rights in non-dominant trademarks and portions of trademarks. So again, using the Facebook example, going after anybody who uses the term book, right, and tries to register in class 9, 41, or 42. Even if it's a completely different service description, as long as they sort of pop up in that class, they're gonna, slap them with an opposition, argue that we are famous because we've got all these users. Amazon has done that with respect to Kindle and the like. And so, if we adopt them, and sometimes they have been adopted, we're lowering the burden of proof. And so what I propose is that, we should urge judges and, trademark examiners, TTAB, to scrutinize these agreements carefully, right? Are they attempting to assert, dominant marks, or are they really trying to provide this umbrella effect in a way for non-dominant marks and portions of marks? And then more specifically, I would argue that we need to actually have some sort of theory for fame that we're lacking, and that's and that's sort of why I posit we have this sort of mad reach for all types of different types of evidence that may or may not be relevant. And I argue that if we adopt sort of an interactive theory of fame, where we're really looking at how consumers are interacting with these trademarks, and so looking at web analytics, right, showing numbers. Are you looking at websites that are prominently displaying these marks? And I go further into into the paper how consumers are actually recognizing or learning to recognize trademarks, and I argue that interacting with them through the website spending a decent amount of time on the site may be better indicators than just having this fiction that they've signed up for an account and one time and that's it, right? And therefore the mark, they should be counted as a user that recognizes the mark as famous. And so of course there are always potential criticisms, and so I'll posit to them. Is this a worry over nothing, right? There's been only a few cases and a couple of oppositions so far that seem to have, seem to be going in this direction. And I would say it's a worrying trend, right? That maybe at this moment, it's not, the end-all and be-all problem, but it is a worrying trend. And I argue and I urge that we should probably think about it more carefully before it snowballs into something more problematic. Because, because strength and fame is so hard to prove, judges are amenable to all sorts of newer types of evidence. And so, we have Leah's, great paper on, using, Google search. Well, I've seen that, as I've been sort of digging through these cases and PTO oppositions, I've seen more and more arguments about that, right? Where they come up in the search results, and that they, they extend and they've got all these search results with that mark, just with their mark. And so we have, the tendency to want to bring in different types of evidence, particularly with respect to new technology. And then, another question could be, well, what's wrong with efficiency, right? What would be wrong with adopting such a rationale for the objective theory into trademark law? And I would counter that with, I don't think any of us have ever argued or, in favor of efficiency in trademark law. In fact, you can argue that maybe trademark, particularly litigation, is inefficient, and there are good reasons for it, right? Meaning that we really are looking from this realist perspective, and if we want to bring in this objective theory, then perhaps we need to revisit. Well, maybe we're not maybe we don't want to be so realistic in our search for strength or fame. And so in conclusion, sort of make a a larger conclusion that I argue that before you import a legal theory, you should really scrutinize the fit and perhaps some of the internal criticisms, and that in sort of my thrust is that we shouldn't adopt this objective theory of contracting into trademark law, at least not to prove fame. There may be other areas where it could fit, although I can't think of any. And so I'll end there, and I welcome your feedback. So Jake.
So I like the idea. I agree with you that we should be skeptical of these contracts. I mean, we've had the same problem with fair use, right, where we're trying to contract away fair use for sale. Other kind of fundamental contours, traditional contours, if you want to use the term Justice Ginsburg doesn't like anymore, of copyright law. I'm a little concerned, though, that you might be conflating the problem of using the contract as evidence and the problem of using the number of consumers as evidence. Because honestly, if 30 billion people are on Facebook, that strikes me pretty good evidence that they've at least got a colorable argument that they're a famous mark, regardless of what the contract says. And I don't think clicks on the contract should count. So, and maybe you've thought about how to separate those more clearly. It may be that I missed a beat in your presentation, but I suggest some care there. And that's all I got.
Okay, yeah. So that's a great comment, and I have thought about that, and so that's why I really argue more in favor of this, the separation between that, where it comes to non-dominant trademarks and portions of marks, right? That I see that's where for a dominant mark, then using the user numbers as good evidence, particularly where it's backed up by perhaps constant users, monthly active users. Well, you don't see that, right? You just say we've got 30 billion or however where they are now, 2 billion users of Facebook. You don't see that, broken out, and so that is actually what I am arguing. For dominant marks, you got to break it out. Yeah, Devin.
So the terms, I think you guys, they basically remind me of stuff I saw in more real licensing deals, right? Like when a major company is in merchandising, that's exactly what you put in.
Right.
And you're doing it because of the rules of policing and quality.
Yep.
So you might want to, maybe you're getting to lean on the fact that this is a very different contract.
Yes.
And then, as I think most people have been in practice now, there's a possibility it was just borrowed because that's what you do as a lawyer, right? They're using these terms from a whole other world, and then, so then I think Nancy got this, but the whole literature and privacy and others that these are adhesion contracts. They're nothing like an objective contract. Right. And the question would be, well, why do they actually include them? And it's not entirely clear, right? And it strikes me maybe a little bit to what Jake was saying is, before professional sporting events, right, on TV, this ridiculous overclaim. Anything you do, you know, if anyone's reading these things, this seems to be more of that we're going to just scare you and in fact lie about what you can and can't do with these.
Right.
And so that might be a way to further flesh it out and compare it. And it's sort of, I don't know if it's used, but it seems close.
Okay, that's great. Hi.
So, can you just help me think about how the scope of the problem? When you say what you're saying about contracts, I think a lot about the general problems with traditional secondary meaning proof, right? And a lot of it is not a very plausible proxy for what consumers actually believe, right? Just the showing of ads, right?
Right.
And this is just being the user of Facebook. And so when you think about this issue, are you thinking about something that is a chance to correct the problems that we have with traditional proofs of secondary meaning, that we can do better in the online realm, or is it?
Yeah, actually, yeah, you kind of hit the nail on the head. I'm sort of near the end when I propose my, interactive theory of, I guess, distinctiveness, for lack of a better word. That's sort of what I'm saying. I'm saying we should try to solve that problem, and then therefore perhaps we wouldn't have this other problem where we're reaching for other areas.
So in a perfect world, it would bleed back, and maybe we'd be more skeptical of advertising.
Exactly. Sort of Jim Gibson's reverse accretion. Yeah, Laura.
So this actually might follow on my point, but I wonder if there's a way of thinking about this, and I don't know as much about contract theory as you do. So these sorts of terms in these agreements aren't really an engagement of agreements to do something.
Right.
They're really a sort of, we would like you to just think about this, Mark, in this way, right? And consumers in agreeing to hold back or take any particular action, right? And in that sense, it is sort of almost working into the kind of advertising, please use Xerox with a capital S.
Right.
Or letters to dictionary editors, please, put a circle R next to this, which aren't sort of contracts in the strict sense, but are sort of almost tacit. We would like you please to do this, and if you do this, you sort of, okay, now it's almost a performance, agreement by performance, right? If you perform in this way, we're then going to take this as proof that this premise that we started with was correct. And so I don't know if there's a terminology to use to describe that.
Yeah, no, that's really handy to think about.
It's the show up with a white carnation in your lapel. You have agreed to do this.
Right,
kind of contract,
absolutely.
Right.
Yeah,
So,
no, that's good to think about. Yeah. All right, great. Well, for those of you I didn't get to, I'm sorry, and feel free to email me. I would love to hear your comments, and thank you.